Hi, good evening, ladies and gentlemen.
Good evening.
Good evening. Dinesh, do you
Good
remember?
evening, sir.
Yeah, what we discussed last session about the law of agency or agency law. Am I correct?
Yes, agency law. I think it is already completed.
Yeah. Now today, law of contract or contract law. Today our topic is law of contract or contract law, contracts law. I hope, we have already discussed the MBO, Maternity Benefits Ordinance and Factories Ordinance as well, right? If I'm not mistaken. And we have a couple of, very few legislations. 2005 Budget Relief Allowance of Workers Act, 2016 Budget Relief Allowance of Workers Act, and 2016 Minimum Wage Act, right? These are the, the left, right, behind, and we will be discussing, right, those things. Today is this 24th or 25th?
24th.
24. Right. Who is speaking is a very, very familiar voice. Is Dinesh or?
Yes, sir.
Okay, right. Today is law of contract. Right. Okay, let's start. These are outside of the agency law and the contract law, are outside of the labor law or industrial law, right? However, these two are important. Important in the sense it has been included. These two topics have been included in the syllabus. So therefore, those are important. But in terms of examination, these two, agency law and contract law, are not that much important. You will be having, let me put in this way, very few, maximum 2 or 4 questions, right? MCQs will be raised from these two, agency law and the contract law. No big, what do you call this, descriptive type of questions from these two, but you have to know the basic. Ladies and gentlemen, your topic today is contract or law of contract or contract law. Take your note, contract law, law of contract. And under that topic, subtopic is definition and forms of contract. Definition and forms of contract. For me, this is not important, but I don't know, right? Previously, this syllabus, when someone has, when someone has prepared in the syllabus, these two has been included. But for me, it's not important. The question paper will be prepared by myself. So I'm repeatedly saying that this contract law, and I'm focusing the industrial law or employment law or labor law. However, these two have been included in the syllabus. I will discuss it, and maximum for multiple questions, multiple MCQs, not multiple, MCQs. Yes, multiple questions, right? Answers will be given. Maximum 4 from this one and the agency law will be raised, but no descriptive type of questions will be raised from these two. Further, we have to discuss, as I told you, workman compensation, 2 Budget Relief Allowance of Workers Act 2005 and 2016. Have we discussed the Minimum Retirement Age Act? Not yet.
No, sir.
No. So remember that we have 2 BRAVA, Budget Relief Allowance of Workers Act, and the Minimum Wage Act, Minimum Retirement Age Act, ETF Act, if I'm not mistaken, ETF, right? And Workman Compensation Ordinance. These are the ordinance and acts that we have dealt with, that we have to deal with. Okay. We have a couple of, today is 25th one. So we have another, 7, 8 sessions. We will be discussing those things during the remaining period. Okay. So, ladies and gentlemen, the law of contract is concerned about the legal enforceability of promises. Make a promise එකත් එක්ක. බලාපොරොත්තු promise පොරොන්දු වීමත් එක්ක වැදිච්ච එක. The law of contract is concerned about the legal enforceability of promises. Promises. In that context, a contract may be described as an agreement that the law will impose. This notion of enforceability is central to the contract of law. Enforceability is central to contract law. If you break or breach the contract, the other party have several legal remedies. Firstly, he or she can sue. Sue means, take legal action. Sue you for damages, for breach of contract. Also, he or she can ask the court to order you to perform the contract. And if you break or breach means breach the contract, the other party has several legal remedies, as I already told you. This is an agreement between 2 parties. Okay. So, ladies and gentlemen, without wasting time, take your note. First subtopic, definition and forms of contract. Definition and forms of contract. This is a bullet form, right? Take your note, first bullet. The law of contract is concerned. The law of contract is concerned about the legal enforceability of promises, porondu. Second bullet form, second bullet, code star mark. In that context, comma, a contract may be described as an. Described as an. A-N-N. An agreement as an agreement that the law will impose. Next bullet form. This notion of impossibility, this notion of impossibility is central to contract law, Next bullet form. If you break, within bracket, breach, B-R-E-A-C-H, breach, B-R-E-A-C-H, breach, close the bracket. Break කියන එක breach, කඩල, ඒ කියන්නේ violate කරනවා, breach. The contract, comma, the other party has several legal remedies. The other party has several legal remedies. Full stop. And continue. Firstly, he Stocksy. Can sue, S-U-E, sue. Sue කියන්නේ නීතිමය ක්‍රියාමාර්ග ගන්නවා කියන එක. Can sue. Can sue you. ඔබට එරෙහිව. Firstly, he Stocksy can sue you. ඔබව නීතිය ඉදිරියට ගේන්න පුළුවන්. For damages. For breach of contract. කොන්ත්‍රාත්තුව බිඳ දැමීම සම්බන්ධයෙන් ඔබව නීතිය ඉදිරියට ගේන්න අගතියටපත් පාර්ශවයට පුළුවන්. Full stop. Continue. Also, come on. Also, he Stocksy can ask the court to order you to perform the contract. To perform the contract. Right. Example. I'm giving you example for that. Example. So, listen first and then you can take your own note. Example. Mr. Saman has agreed to sell his land to you for an agreed price. You later hear that Mr. Saman is planning to sell the same land to another person. You can ask the court to order Mr. Saman to sell the land to you as agreed and also for an order injunction to prevent Mr. Saman from selling the land to the other party. ඔබ සමන් කියන කෙනා පොරොන්දු වෙනවා එයාගේ ඉඩම විකුණනවා කියලා. පොරොන්දු බෑ ඉතින් ලිඛිතව තියෙන්න ඕනේ. පස්සේ ඔබට ආරංචි වෙනවා සමන් ප්ලෑන් කරනවා මේ ලෑන්ඩ් එක වෙන කෙනෙකුට විකුණන්න. දැන් ඔබට ලිඛිතව තියෙනවා නම් සමන් දීපු ලෙටර් එකක් හරි මොකක් හරි. ඔබට කෝට් එකට යන්න පුළුවන්. උසාවියට යන්න පුළුවන්. ගිහලා කියන්න පුළුවන් සමන් මේක විකුණන්න හදනවා මට පොරොන්දු වෙලා තියෙන එක ප්‍රොමිසස්. රයිට්. ඒක කඩ කරලා තියෙනවා. ඒ නිසා මටම මේක විකුණන්න කියලා ඕඩර් එකක් දෙන්න සහ වෙන කෙනෙකුට විකිණීම වළක්වන්න ඉන්ජන්ක්ෂන් එකක්. ඒකට ඕඩර් එකක් දෙන්න කියලා. Do you understand? Hasini, is it clear? Is it clear to you, Kavisa?
Yes, sir, clear, but if you can explain it again, it is good, sir, because there is a signal drop. We haven't power.
Okay, right. Definition and forms you have already noted, right? So if you break or breach the contract, the other party has several legal remedies. Example, Mr. Saman has agreed to sell his land to you, for example, for an agreed price. You need to have it in writing. You later hear that Mr. Saman is planning to sell the same land to another person. So then, if you have the legal or document in writing, right, agreed by Mr. Saman to sell the land to you, then you can go to court and ask the court to order Mr. Saman to sell the land to you as agreed, and also for an order means injunction, to prevent Mr. Saman from selling the land to other party. Is it clear? Right. You take
Yes.
your notes. මේ example එක ඔයාලම ලියා ගන්න. ලියා ගන්නව නේද?
Yes, sir.
Okay. මට කවුරු හරි කියනවද මේකේ කීවෙනි lesson එකද අද යන්නේ? What is the lesson number today?
24, sir.
Okay. Have you done? Finished? ඉවර නම් කියන්න. Have you done? Please tell me. ඉවරද?
Yes, sir.
ඇහෙන්නේ නැද්ද
Finished. Finished, sir.
Okay, okay, right. So let me go through today. Okay. Next. You know, at the outset, it is important to note that contract law in Sri Lanka is part of the law of obligation and is governed by Roman Dutch law. So contract law in Sri Lanka is governed by what? Roman Dutch law. However, right, there appears to be no fundamental difference except in one or two main cases, areas, such as the requirement of consideration between the Roman Dutch law and English law, right, in relation to contract law, contracts. So with regard to contract law, yes, contract law is governed by the Roman Dutch law, but there is no much difference between contract law and, Roman Dutch law and the English law with regard to contracts. Secondly, it should be noted that contract law is largely based on judicial decisions, judge-made laws, rather than in a single statute or code. Although in some areas affecting contract law, for example, sales of goods, and more recently, consumer protection legislation plays a major role. So what I'm trying to tell you through this slide is the contract law in Sri Lanka is governed by Roman Dutch law, but there is no much difference between Roman Dutch law and the English law as far as the contract law is concerned. That is the message I need to give you. Okay. Next para. I will summarize this because you will have this presentation. I don't need to repeat what is there in the slides, because you will see this slides. Okay. So the contract law in Sri Lanka, the contract law in Sri Lanka is part of the law of obligations, part of the law of obligations, part of the law of obligations, and is governed by the Roman Dutch law. The Roman Dutch law. However, there appears to be no fundamental difference. There appears to be no fundamental difference. There appears to be no fundamental difference between the Roman Dutch law, Romalandis initial, Saha, between the Roman Dutch law and.
Excuse me, sir, can you repeat? However, there appears to be no fundamental.
However, there appears to be no fundamental difference. However, there appears to be no fundamental difference, except in, the fundamental difference between the Roman Dutch law, and English law right. However, there appears to be no fundamental difference between Roman Dutch law and English law in relation to contracts. In relation to contract. In relation to contract. Next para. Next para. Next para. Next para. It should be noted that contract law is it should be noted that contract law is largely based on contract law is largely based on contract law is largely based on judicial decisions judicial decisions judicial decisions rather than in a single statute or code.
Excuse me, sir. Can you repeat rather than in a single
statute or code, C-O-D-E code. Right, next, how to raise a contract. How to raise a contract. How to raise a contract. So, ladies and gentlemen, now next subtopic is how to raise a contract. Next subtopic is how to raise a contract. Ladies and gentlemen, a contract means an agreement. Contract means an agreement which is enforceable by law. That is more important, right? So contract should have, there should be ability to enforce the contract, right? Agreements, you and someone, right, make an agreement. So it should be enforceable. That is what we mean by contract. Okay. So contract means an agreement which is enforceable by law. An agreement consists of reciprocal promises. Reciprocal, you and some other party. Reciprocal promises between the two parties. In a contract, each party is bound by the promises made by him or her. A contract could arise the contract could arise in following way. One, by agreement and contract, by standard form contract, by promissory estoppel. Okay, you take your own note, right? You take your own note. මේක ලියාගන්න. When you finish, let me know. Ivaradha, have you finished? Have you done?
Yes, sir.
Right. Next, types of contract. You know, there are several types of contracts. The most common types under English law are: one, contracts of record, contracts under seal, and simple contract. The Roman Dutch law that applies in Sri Lanka does not recognize the above distinction, and all contracts are treated as simple contracts. Under the English law, there are types of contracts. One is contracts of record, contracts under seal, contract or simple contract. But under the Roman Dutch law that applies in Sri Lanka does not recognize the above distinction, and all contracts are treated as simple contracts. So take your note. ඔයගොල්ලෝම ලියා ගන්න. ඉවරද? Have you done? Have you finished? ඔබ අවසන්ද මේ කොටස? Now you remember how to raise a contract. Number one, agreement and contract. So agreement and contract, subtopic. Agreement and contract. So look carefully, right? An agreement impossible by law is contract. ඒ කියන්නේ ඕනෑම givisුමක් නීතියෙන් බලාත්මක කරන්න පුළුවන් නම් ඒ කියන්නේ ඕනෑම ඒ කියන්නේ පොරොන්දුවක් givisුමක් නීතිය මගින් බලාත්මක කරන්න පුළුවන්. හැබැයි හැම givisුමක් all agreements are not impossible by law and therefore all agreements are not contract. All contracts are an agreement based on an agreement, but all agreements are not contracts. Agreements to go to see a example movie, agreement to play a cricket match, agreement to go for a dinner with your fiance may not contract, but reverse is not the same. All the contracts are agreement. Do you understand, ladies and gentlemen? ඒක තේරෙනවද? ඒ කියන්නේ agreement එකක් එකගතාවයක් ඇති වුණ පළියටම ඒක කොන්ත්‍රාත්තුවක් වෙන්නේ නැහැ. කොන්ට්‍රැක්ට් එකක් වෙන්නේ නැහැ. හැබැයි සෑම කොන්ත්‍රාත්තුවක්ම ඇති වෙන්නේ agreement එකක් මත. ඒතර කොන්ත්‍රාත්තුවක් අනිවාර්යයෙන්ම agreement එක්ක ප්‍රතිඵලයක්. හැබැයි හැම agreement එකක්ම කොන්ත්‍රාත්තුවක් නෙවෙයි. That is what it says. An agreement impossible by law is contract. ඒ කියන්නේ නීතිය මගින් බලාත්මක කළ හැකි givisුමක් කොන්ත්‍රාත්තුවක්. හැබැයි හැම givisුමක්ම කොන්ත්‍රාත්තුවක් නෙවෙයි. Is it clear? ඔයාලා කවුරු කතා කරන්නේ නැහැනේ ළමයි. But anyway, I don't care. This is my last batch, no? I'm not going to. Okay. Agreement and contract, next subtopic. And take your own note. This one. Agreement and contract. Okay, I will read it. Subtopic, agreement and contract. First bullet. An agreement impossible by law. Impossible by law. Impossible by law is a contract. Ladies and gentlemen, an agreement impossible by law, an agreement impossible by law is a contract. Is a contract. Next bullet form. All agreements are not enforceable by law. All agreements are not enforceable by law. All agreements are not enforceable by law. And therefore, all agreements are not contracts. All agreements are not contracts. All agreements are not contracts. Example. 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 Agreements to go to see a movie. Agreements to go to see a movie. Comma. Agreement to play a cricket. Right. Next bullet. Next bullet. Yes, next bullet. How, right, but reverse is not the same. But reverse is not the same. Comma. All contracts are agreements. All contracts are agreement. Right. Next subtopic. Contracts of record. Contracts of record. What does it mean? Ladies and gentlemen, contracts of records are judgments of court of law and other recognized tribunals. Example, if during litigation, the contesting parties agree to a settlement of the case and the judge records that settlement in writing, such settlement is called a contract of records and is binding on both parties. Okay, this is the another way of arising contract of records. It means contract of records are judgment of court of law. Niti judgment. උසාවියෙන් දෙන නියෝග තීන්දු. එතකොට ඒ තීන්දු රෙකෝඩ් කරාම ඒවා පූර්ව ආදර්ශයක් වෙලා. එතකොට ඒවා පදනම් කරගන්නවා මොනවටද? contract law එකේ යටතේ. Hello, do you understand?
Yes, sir.
So you take your note, contract of records, right? So once you finish, let me know. මම 10ට කලින් යනවා ලසන්තා. maximum 10. හරි. Have you done? If did you finish, ladies and gentlemen?
Yes, sir, finish.
Now, the third one, contract under seal. Contract under seal. What does it mean? You remember that, you know, how contract is arised. You remember here, right? Yes. How to arise a contract. Agreement, standard form contract, and promissory estoppel. Right. So we are discussing these things. And then, then the type of contract. This is important. Contracts of record, contract under seal, and simple contract. Agreement, contract of record, contract under seal. What does it mean? A contract under seal is also called a deed, opua, or a specific, right? Specialty contract. Deed can opua, specialty contract. This is a මේවා දල වශයෙන් මතක තියාගත්තාම ඇති මේවායින් කිසිදු දවසක ලොකු ප්‍රශ්න අහන්නේ නැහැ විභාගෙට. මේක මේ අමතරව දාලා තියෙන එකක්. ඇයි දන්නේ නැහැ මේක දැම්මෙත් මේකට. කොහොම නමුත් මමයි පේපර් එක හදන්නේ. මම මේකෙන් ලොකු ප්‍රශ්න අහන්නේ නැහැ. කෙටි ප්‍රශ්න විතරයි අහන්නේ. So a contract under seal is also called a deed or a specialty contract. This is a contract which is in writing. Under seal means writing and signed by both parties and is formally executed by affixing of a seal. එතකොට අර දෙපැත්ත අසං කළ seal එකක් තියෙනවා. Right. ඒක තමයි මේ කියන්නේ. Example. Right. Convenience relate to property. If you buy or sell a land, a notary must notarily execute the contract with two witnesses. In Sri Lanka, a seal is not used link in, right, make a avashane, right, in England. Like in England, sorry, used like in England. මේකේ කියන්නේ මොකවත් නෙමෙයි. contract එකක් දෙගොල්ල පාර්ශවයක් අස්සම් කළා ලෝයි කෙනෙක් ඉස්සරහා seal එකක් තියලා කරනවා කියන එක. right. ඒකේ මහ දෙයක් නැහැ. So you take your own note. මං කියන්නේ මගේ කට රෙදෙනවා. උදේ ඉඳලා මම lectures. So I'm giving you time to take your note. And also by 9:40 or 9:45, today I'm going to stop this session. 1 hour prior to the scheduled time. Because I'm not feeling well. Let me know when you finish. ඉවරයි නේද?
Yes, sir, finish.
Now, contract under seal. Contract under seal. Right. Take your note. I will read it. A contract under seal is also මේකත් ඒ වගේ. A contract under seal is also.
So that one we already written, sir.
Sorry.
Contract under seal we have written, sir.
Yes. Sorry. We have written. Sorry. Oh, sorry. Simple contract. Sorry. I made a mistake. Simple contract. You know, ladies and gentlemen, these contracts are the most common type of contract. Most business contracts are simple contract. A simple contract may be in writing or be made verbally or by conduct. No formalities are required for simple contract except where required by legislation. The legal rules relating to contract discussed below, right, apply to simple contract, right? We will discuss below, right? Take your note, simple contract. Simple contract. Right. First bullet. Simple contracts are.
Excuse me, sir. The topic is simple contracts now.
Yes. Topic is simple contract, right? So first bullet, simple contracts are. Simple contracts are the most common type of contract, full stop. Most common type of contract. Most business contracts are continue. Most business contracts are simple contracts. Next bullet. A simple contract may be in writing in writing or be made verbally, or be made verbally. Or by conduct. The other things you don't need to write everything. Let me give you in simple way. Now we are trying to deal with the definition and requirement of a contract. What is the definition and the requirement of a contract? Ladies and gentlemen, a contract is an agreement between two or more parties, which will be imposed by law. නීතිය මගින් බලාත්මක කර හැකි parties දෙකක් හෝ වැඩි ගණනක් අතර ඇතිවන එකඟතාවයක්. As stated earlier, the general law governing the contract in Sri Lanka is the Roman Dutch law, which is the country's common law. රටේ පොදු නීතිය තමයි Roman Dutch law එක. Apart from Roman Dutch law, certain areas of contracts are governed by statute law and also by English law. Statute law කියලා කියන්නේ අපේ හදපු පනතක් මගින්. An agreement imposed by law is a contract. All agreements are not impossible by law, and therefore all agreements are not contract. But reverse is the same, right? We have taken notes in this regard, but take notes with regard to first one. Definition subtopic, definition and requirement of a contract. Definition and requirement of a contract. Definition and requirement of a contract. මන්දන මේකෙත් තින්නේ 11යි 12යි දැන් ලොකු ගණනක් ඉන්නවා මේ. But anyway, this is my last batch that I'm conducting lectures. No more lectures in the future. Okay. A contract is an agreement. ලියන්නේ යටතේ. First para. A contract is an agreement between two or more parties, which will be imposed by law. Which will be imposed by law. Which will be imposed by law. As stated earlier, ඉහතින් සඳහන් කළ පරිදි, as stated earlier, comma. The general law governing the contracts in Sri Lanka, is the Roman Dutch law, which is the country's common law. Common law. Next para. Next para. An agreement impossible by law An agreement imposable by law. Imposable by law. An agreement imposable by law is a contract, but all agreements are not contracts. All agreements are not contract. All agreements are not contract. The Gratuity Act. I highlighted certain, the one case regarding Siga Sri Lanka. I explained to you that one. The management of Siga Sri Lanka offered to the union saying that the company is willing to pay 75% of or 3/4 of gratuity for those who have served more than 20 years for the company. Then 50% නේ. වැටුපෙන් 50% නේ. භාගයයිනේ. භාගය වෙනුවට 4න් 3ක් ගෙවන්න පුළුවන්. Do you remember the case I explained to you? Do you remember? I don't think so.
Yes, sir.
You remember?
Yes, sir.
Okay, right. So finally, it went to the arbitration and Court of Appeal and the Supreme Court as well. Supreme Court set aside and dismissed the application because yes, there was a proposal offer, but there was no acceptance. මතකද මං කිව්වා? Union එක make neither accepted nor rejected. Ena agreement එක ඇති වෙන්න මොකද්ද තියෙන්න ඕනේ? There should be two conditions to be satisfied. One is offer or proposal and the acceptance. මතකද දිනේස්? මම ඕක කිව්වා.
Yes, remember.
Right. Right. A promise is a result of offer and acceptance. මේ දෙක highlight කරගන්න. This promise is known as agreement. Full stop and continue. Continue. This promise is known as an agreement. Full stop. And then if this agreement satisfies all the basic element of a contract, then it becomes a contract. Then it becomes a contract. Then it becomes a contract. Requirements for next subtopic, requirements for there to be a contract. Can give you some අවශ්‍ය requirement මොනවද? Requirements for there to be a contract. Ladies and gentlemen, there are a couple of requirements. 7. One is there must be an agreement between two or more persons or parties. Instead of persons, you may write parties. You may put parties. Right, two parties. The parties must intend that the agreement will result in legal relation. Third, the contract must comply with any required statutory formalities. Number 4, in English law, there is a requirement that the agreement must be supported by what is called consideration. However, the Roman Dutch law, which applies in Sri Lanka, does not require consideration. In Roman Dutch law, any good or valid reason which is expressed by the Latin term justa causa will suffice for a contract. Number 5, the parties to the agreement must have legal capacity to contract. අවුරුදු 18ට අඩු කෙනෙකුට කොන්ත්‍රාත් වලට එන්න බෑ. අඳ ගොළු බිහි කියන්නේ මෙලෝ 100කින් නැතුව ඉන්න කෙනෙකුට කොන්ට්‍රැක්ට් එකකට එන්න බෑ. That is what we mean. The parties to the agreement must have legal capacity. Legal capacity. You should be above 18 years of age. You must read. You must have the ability to read and understand. Right? You should be right in good health, mentally and physically, rather mentally. Okay. For example, a contract with a person who is mentally unsound is not valid. Number 6, the agreement must be genuine and not be right affected by factors such as mistake, misinterpretation, misrepresentation rather, fraud, undue influence, and duress. Number 7, the agreement must be for a purpose of object, which is not illegal or contract contrary to public policy. ආයුධ වෙළඳාම් කරන්න කිවිසුම් ගහන්න බෑ. මත්පැන් වෙළඳාමට හොර මත්පැන් වෙළඳාමට කිවිසුම් ගහන්න බෑ. Right. කුඩු ජාවාරමට කිවිසුම් ගහන්න බෑ. Those are illegal. So these are the requirements for there to be a contract, ladies and gentlemen. So you take your own note. Let me make it larger. Yes, this is one. I think, is it visible? Is it visible, ladies and gentlemen?
Yes, sir.
Okay, take your note. And once you finish, let me know. Do you need more time? Dinesh?
Yes, sir.
Okay. මේ කොටස විශේෂයෙන් මතක තියාගන්න සමහර වෙලාවට ලොකු ප්‍රශ්නයක් ඒ කියන්නේ මේ කරුණු ටික ලියන්න කරුණු පහක් ලියන්න විභාගෙට එන්න පුළුවන්. මේක highlight කරගන්න. At least 5 points. Requirement for the contract. Too tired, ladies and gentlemen, today. Sunday is sped up from morning up to 9 to 12, 5 to 8, 8 to 11. 11, I can't go up to 11, but don't worry about that. You know, time is not important. Subject matters are more important than the time. But I will catch up, the missed time during incoming sessions, rather. Oof. Hasini, did you finish? Kamunu?
Yes, sir.
Dinesh?
So I completed the others.
Okay, let's see others. Hasuni, sorry. Jayaratna?
Yes, sir.
Okay. Then shall we move to another session, another slide? Right. Next subtopic is intention to create legal relations. Intention. බලාපොරොත්තුව කියන්නේ intention to create legal relations. Ladies and gentlemen, an agreement alone will not create a contract binding in law. An agreement alone, agreement එකක් වුණ පළියටම ඒක තනියවම will not create a contract binding in law. නීතියෙන් බැඳී සිටින කොන්ත්‍රාත්තුවක් බවට පත් වෙන්නේ නැහැ නිකම්ම agreement එකක් තිබ්බට. A critical factor in the formation of a contract is the necessity for an intention by the parties to create legal binding obligation. ඒගොල්ලන්ට intention එකක් තියෙන්න ඕන නීතිමය වශයෙන් බැඳීමක් ඇති කරගන්නවා කියන එකට. Unless the intention of the parties is to constitute an agreement enforceable at law or by law, there will be no contract. I hope this you can understand this, right? So next subtopic, intention to create legal relations. Okay, I will read it and you take your note. Intention to create legal relations. An agreement alone will not create a contract. Will not create a contract. Will not create a contract. Binding in law. Binding in law. A critical factor. A critical factor. In the formation of a contract. In the formation of a contract. In the formation of a contract. Is the necessity for an intention. Is the necessity, අවශ්‍යතාවය, for an intention. Intention, බලාපොරොත්තුවක් තියෙන, intention. By the parties. By the parties to create legally binding obligations. Legally binding obligations. Full stop. Unless ඇවිල්ලා පොඩ්ඩක් තේ එකක් හදලා ගමු. Unless the intention of the parties is to constitute ඒ කියන්නේ දෙගොල්ලම බලාපොරොත්තුවක් නැත්තම් මේ ලෝ එක මගින් ක්‍රියාත්මක වන බලාත්මක කර හැකි ඇග්‍රීමන්ට් එකකට එන්න එතෙක් contract එකක් නැහැ, right? Unless the intention of the parties is to constitute an agreement enforceable by law, enforceable at or by law, there will be no contract. There will be no contract. Right. Next bullet form. Domestic stroke social agreement. Domestic stroke Al-Iraq social agreements. Generally, agreements are A-R-E-R, generally not contracts. Example, give me, you don't need to write this example, but I will tell you the example. For example, if Mr. Pereira agrees to lend his bicycle to his friend, Mr. Silva, and not older, right? Later, sorry. And just some mistakes. Later, refuses or fails to do so. Mr. Silva will not be able to sue, again, Nithime Kriyamarganda against Mr. Pereira for a breach of a contract. This is because Mr. Pereira's promise was a social nature. Samaj mein, a promise by a friend to another friend. Neither Mr. Pereira or Mr. Silva would have contemplated legal action when he promised to lend the bicycle. These are social norms. Then, agreements between business people are presumed to be contract. Presumed to be contract. What is that? When business people or commercial institutions enter into agreements, there is a presumption that such agreements result in legal enforceable contract. Example, Mr. Silva and Mr. Pereira are two businessmen. They are also good friends. Mr. Silva agrees to sell a property to Mr. Pereira for an agreed price and execute a notarial document. Nithima notarial, notarial document to that effect. Mr. Silva tells Mr. Pereira, although I agreed to sell that property to you, I have now changed my mind and I have decided to sell it to another party. Despite their close friendship, Mr. Pereira can take legal action against Mr. Silva to impose the written agreement since it was a commercial transaction. However, you remember that there should be a legal document, right, with regard to agreement. It's a notarial document. Okay. So you take your own note. Slide number 16. Subtopic agreements between business people are presumed to be contract. These are the example. You take your own note. ඔගොල්ලෝ මේක ලියා ගන්න.
Can you enlarge the screen?
Yeah, sure. I'm trying to do it. By 10, right, I will stop and Ladies and gentlemen, when you finish, let me know. Right? Once you finish, I'm going to stop the session for today. So therefore, once you finish, please let me know. We have another 10 sessions to be conducted. No worry about the subject matters. We have plenty of time and we have very few legislations, small legislations to be completed. But the final day, whole day, completely, for 3 hours, I will be summarizing you what we have learned so far. Maybe, last 2 sessions, and I will be highlighting the questions that will be raised at the examination. So therefore, last 2 sessions, don't miss the last 2 sessions. Today is 24th one. We have 34, another 10 sessions. It takes another 2 or at least 1 session to be completed this one. And we have a couple of another legislations. And also I'm going to discuss with you in 3 hours. It is not the international labor conventions and its implication on Sri Lankan labor law. Even though that topic is not there, not included in the syllabus, but that is more important because our labor legislations have been amended according to the international conventions, ILO conventions in particular. Okay? Have you finished?
Yes, sir.
Aviza is okay. Kasuni, what about Kasuni?
Yes, sir.
Gamunu?
Completed, sir.
Dinesh?
Complete, sir.
Right. What about Sitmi Hasara?
Yes, sir. Clear. Clear, sir.
Okay. Okay, good. And then Hamza? Hamza, I'm talking to you.
Yes, clear, sir.
Okay, good. So therefore, ladies and gentlemen, you have to tell me because, okay, let me take my own notes. Otherwise, you, in case, if you do not remember, but English medium, since I don't have any problem, but single medium is, I am conducting 2, but so we have done contract law up to slide number 13. Sorry, 16. 16 slide. Okay, do you permit me to stop at this moment? Or do you want me to continue? Is it okay?
Sir, you can wind up the session now.
Dinesh, what do you think? No worry about the, we have plenty of time, right?
Yes, sir. Okay, sir. There is a small correction.
Yeah.
That's you have that mention. Sometimes the previous court decisions are taken as considered for another decision, but
Yes.
sometimes some courts are giving wrong decisions that are challenging superior court. What type of court decision are taken into consideration for future considered.
No, I mean, I can't say exactly, with regard to this contract law, I can't say exactly. This is because, we have all court decisions, in England law, right? English, the British decisions. All right, we have very few, the local decisions, but every, the court highlights the British decisions. So why I have not highlighted these decisions in this one, according to my understanding, right? These are not coming under the industrial law. This is something else, because as you are studying human resource management, uh, uh, I don't feel any connection with the human resource management and the contract law and agency law. But when it comes to marketing, yes, under the marketing, contract law and agency law are somewhat important. So that is why I have not highlighted any court decision. But however, if there is a disagreement, either party can go to court. We don't know, right, what decision will be given by the court. If court, if one party is unsatisfied with the decision given by the court, there are superior courts that the affected party can go. So that is what I can say up to now, Dinesh.
Okay, sir. Thank you.
Right. These are, you don't need to focus much on these things. If you are undertaking marketing, yes, there are, the trade agreement, right? So then agency law and what do you call this, contract law are somewhat important, right? But not in HR, not in HR. So that is why I have not highlighted court cases. If you need, later I will give you reading materials. It contains plethora of British, the court decisions. Okay, then, ladies and gentlemen, let me wind up the session, right? Thank you very much for listening and questioning. I like when people raise questions. So we will meet another day and continue up to 3 hours continuously, but don't worry about the time, right? What is important is whether we have adequately covered the session. My personal view is 24 sessions are sufficient to cover these syllabus. But unfortunately or fortunately, I don't know, they have put 34 sessions. My understanding is 25 is sufficient to cover the industrial law. Okay, ladies and gentlemen, then good night for everyone.
Nice.
Thank you, sir.
Okay,
Good night.
Good night.